Go ahead and do a quick introduction of our feature speaker today, Sahalu Okabato. He's an electrical engineer who graduated from San Jose State University. He's currently working as a primary patent examiner for the United States Patent Trademark Office. He's been with the office for the past 15 years, and he currently serves as IP Champion, which aims at creating awareness about intellectual property among communities. So I would like to welcome Mr. Okabato to his presentation here today, who's going to teach us a little bit about fundamentals of IP and using IP to take your business to the next level.
So today we're going to have four talking points. So the first one is what intellectual property is, who provides IP protections, what type of IP protection exists, and where can we go to find out more about the resources. So as you see, there are a physical property and intellectual property. The physical property, it's commonly see your car, your house, whatever you own physically. The intellectual property is, as the name itself says, it's started in your mind. So all is in your mind. So you don't have to have a prototype or physical item in order to have a patent or to have intellectual property. That's why the name itself says intellectual property. The intellectual property is actually protected by the government. It is territorial. It will not work outside the United States. But if you have an idea, if you have a problem-solving solution, if you have any new ideas, if you have a business to have a trademark, if you have a business, a trade secret, if you have music or movies or whatever, those properties yours will be protected for a certain period of time. You will have exclusive right to corresponding your work. So what is United States Patent and Trademark Office? So if the government wants to protect your intellectual property, there has to be a system, right? So the patent office comes into play. The patent office actually, there are more than 13,000 employees working for Patent and Trademark Office. So there are examiners, there are trademark attorneys, and the copyright and trade secret managed by Congress. So the patent office has resources. For example, there are, I mean, if you're a student, if you don't have enough resources to apply for a patent, or if you don't know how to process it, if you have a new idea, the patent office has actually a lot of resources. If you want to find out whether your idea was invented before you, there are a search engines you can use offered by the United States Patent and Trademark Office. So you can go there and you can check whether your idea is patented by somebody else or not. And if you have a disadvantageous person, so mostly, for example, from my side, most of the application processed by the applicant's attorney, not by themselves. However, sometimes certain individual or pro-se applicants, they might not have the capacity to pay for the attorney or processing fee. So the patent office see your, your situation and will provide you a resource. So what is intellectual property? There are four types of intellectual property, which are patent, trademark, copyright, and trade secret. So the patent is a new idea or improving one person's idea. So you can get for either improving or a new idea. Trademark is just the origin of the goods or services. You can have if Bank of America had their own brand, so once you see that logo, you can see this is Bank of America, or this is a coffee shop like a Starbucks, those kind of things. So those we'll go in detail later on. Copyright is like writers, a book, music. All those kind of things, it has to be protected. Think about it. If the person to write a book, it might take him probably like 2 or 3 years or even more after you produce all those hard work. And if somebody duplicate your book and if sell it, that would be a disaster, right? So it has to be protected by the government. So the copyright will be protected for the entire life of the owner. If that person's died, the inherentee will own up to 70 years after the original producer died. Trade secret is like most of the company has a trade secret. For example, Apple has a program which no one wants to know it, so they have to find a place to keep that secret. So they have to identify this one is a trade secret. For example, if somebody from Apple unauthorizingly go to that place and copy the trade secret, that's a crime. It can be imprisoned by a certain, that person can be even jailed. So patents start with an idea. So that idea, it can be utility patent or design patent or plant patent. So the design patent, I mean the utility patent, it has to be a process, it has to be a machine, composition of matters. So all those kind of things, for example, if it is a process, the process means how, for example, if the end product is a tire, so that tire actually it process, okay, you can do in this the first stage you have to do this, in the second stage you have to do this, the third stage you have to do this, just a process. They don't get a patent for the end product. They just get it a process. The problem with this kind of patent is this tire, actually somebody can come with different process, they can generate the same result. So it can be protected unless they can duplicate the same process, but in different process, they can do the end of the end product. It can be the same. Tool, so machine is to create some kind of product. For example, if you have a certain machine to product a phone cover, for example, that one is the tool by itself. How it works, the patent owner has to describe how it works. That tool can be patented. And the composition of matter, you can compose 2, 3, or more material together to create a new a new product. So once you create that idea, then you apply for a patent. So provisional application it's optional, but it helps you to get effective filing date. So you don't have to file it formally, but you can just, I have an idea, this is the idea. So you can, it's a kind of a placeholder, but you have 1 year. After 1 year, you have to apply non-provisional applications, which is a formal part. So after that, so it's journey to patent. So that patent, once you get in, the owner have 20 years, mostly like 19 years of ownership. Let's go to the next one. So to go to deep, how the patent process works. So the idea formed, and the owner filed the application, and the application, it comes to our desk, to examiner. So we look at the examination. Okay, this is one important things to know. There are 3 segments in an application. It is drawing, it's a specification, and it's claim. So the reason is a public has to know how this product works. That's why the inventor has to describe, he has to have this component. So the most important part is how you claim your property. So that's the most important part from all those 3. So then we look at it to understand the invention. So we understand, okay, from the drawing, from the specification, the examiner will understand what applicant's invention is. However, it's how they claim it we focus on. Then if similar claimed by somebody else, the patent office has a huge database. We do search the previous patent or publication, and we compare with applicant's claim. And if we find similarity previously, then we're gonna provide that finding to the applicant. Because of this, John Doe actually claimed this kind of intellectual property for you. Because of that, we can provide you that patent, so it can be rejected. So then the applicant can, there is a noise. So the applicant will receive.
Ask speakers to mute your device, please.
Thank you.
Thank you.
So so the finding we send out to the applicant will look at our finding. The applicant may agree or may not. So if they agree with our finding, they will amend it to specific invention they are claiming. If they don't agree, they can argue back. No, we don't argue with your finding. So they can send the application to our desk. Our desk, we can look at it again. I think our decision is firm, so we can send back to the applicant. The applicant have 2 options. One, the patent office has a board, so they can go to the board to challenge the examiner's finding. The board will look at it, the back and forth, the argument and the claim, and if they agree with the applicant, so the patent will be issued. If they agree with the examiner, the applicant has to go to a different process, or it can apply for continuation, or it can be abandoned. But from my experience, most of applications, the abandonment is very, very rare. Mostly, the application will be approved after back and forth. So trademarks, obviously, it's the source of the product, right? So if you there are actually four ways you can apply for trademark. One, it can be word. The second one is it can be a logo. You don't have to write anything. As you see, Starbucks has a logo on the right side, Nike, Target also. Beside word and logo, actually, you can have scent, can have a trademark. Certain scent can be actually trademarked, so that kind of sense nobody can't create. The other one is sound. You can have a certain types of sound, and that sound can have a trademark. Next. So the examples are, this one is non-traditional. It's as you see, the third one, John Deere, it has a logo and it has a word. If they can apply as is, as one application, or they can do two. One is John Deere, they can get that the wording trademark, and that the Godi trademark as a logo as well. Or they can apply for a combination of two. Product has, each of them has a specific distinct smell. So that smell actually has a trademark. This one is I don't know if you guys old enough. So the left side is I think if I remember correctly, it's a bakery. And when you push it, it gives you hoo hoo hoo, that kind of sound. So that actually it can have a trademark. NBC had their own sounds, whether during the commercial or during the news, they have their own distinct sounds. So now copyright. Next, it can be literature, drama, music, artistic, and certain other intellectual works. So the term, the author's life, as I said before, the author, as long as that the author is alive, that person can own the whole time. And after that author's died, the inheritance can own for 70 years. After that, it's gonna be a public. The copyright, it can be songs, movies, books, sculpture, certain design. So that one is actually, it can have a copyright if you have a distinct feature in the design. The trade secret, as I said before, Coca-Cola, KFC, all has some cooking recipes. Those can be, and beside that, it can be a program, it can be a process, how to do certain things. If they have a specific way of doing things, they can claim as a trade secret. So they have to identify as a trade secret. So non-authorized person can't reach to that product. If they get without permission, without authorizing, if they trying to access that one, that's against the law.
sometimes the extraordinary is masked in the ordinary. Take the humble soccer ball, for example. When 26-year-old inventor Jessica O. Matthews got a hold of it, you could say it became a thing of magic. Located in New York City, I met up with Jessica to find out more about one very bright idea she came up with. A special kind of soccer ball called the socket. And it creates the magic of battery-powered light where it's needed most.
Can you tell me a little bit about what this does?
Sure. So this is a energy-generating soccer ball designed for the developing world. Essentially, it's an airless ball, so that means that it doesn't deflate, it doesn't need to be inflated, it just is. Inside of the ball, at the core, there's a mechanism that actually harnesses kinetic energy. That's the energy of motion that actually is generated during play and then stores that power inside of the ball so you can use it as an off-grid power source.
A light plugs into a hidden panel on the ball, and daytime play powers nighttime living and learning.
So basically what's happening is we're harnessing the rotational energy. So as the ball is rolling around the field, we have a mechanism that is actually rolling with it. And with that, you have this pendulum that's turning, basically. You can kind of hear it, yeah.
Sounds like a little happy mouse.
Exactly. The pendulum is turning the motor, which is then powering up the rechargeable lithium-ion battery. And that's what's storing up all the power. That's actually transferring the kinetic energy into electricity. So then when you're ready to go, you would just plug it right in.
And now you have an LED light that can last for how long?
1 hour of play can give you up to 3 hours of LED light.
Jessica's invention was inspired when she made two key observations while visiting Nigeria. One, she saw a very serious lack of access to sustainable power, making studying at night nearly impossible. And two, she noticed that despite difficult living conditions, children seemed transported when playing soccer, happy and carefree. And so, Jessica's work on the socket began 7 years ago when she and her co-founder were students at Harvard. Always working to perfect the ball, the socket is now on its 7th generation, and on this day is undergoing some impromptu and fun impact testing. And it passed with flying colors. Jessica has seen firsthand how kids worldwide not only take to the soccer ball, but to the idea of innovation. The light from the socket is giving them an opportunity to read, to learn, to be inspired.
W-I-N-WIN! W-I-N-WIN!
And so in addition to the soccer ball, she and her team also created a curriculum, which gets kids involved in the invention process.
And so I thought if we could take all of this confidence and this creativity and all this passion and harness it literally and figuratively and actually create something that didn't just provide immediate fun, but could actually create that spark that would get people to feel like they could create the world that they want.
While light from the socket illuminates the pages of school books after dark, it also has switched on a light of possibility in many young minds.